Attorney United School District. We have your justice panel seated and ready. I'd like to introduce our justices over here, and then we will get started with the phone.
I'm J. Allen Eisen. I'm an attorney here in Sacramento. I practice almost exclusively appellate law. I was one of the first appellate law specialists certified by the state bar. And I like to participate in these events. I'm always impressed with how well the students do.
Thank you, Justice Eisen.
I'm Tim Schooley. I'm the managing attorney of the California Court of Appeal Third District here in town.
And I'm Justice Vediga. I am an attorney here in family law in Sacramento. Okay, so West Campus is the appellant. Would you start with your arguments?
May it please the court, my name is Amy Elizabeth from West Campus, and I am appearing on behalf of the appellants. I will be addressing issue number 1. For the following reasons, the district court's decision should be revised. Clearly, the First Amendment protects the rights of the students to participate in a peaceful demonstration, particularly during a school recess and off campus. In the United States Supreme Court case Tinker v. Moyes, the court held that the school district could block the student's speech if the district could show that the speech would materially or substantially interfere with the requirements of appropriate discipline in the operations of the school. In this case, plaintiffs were livid over the recent shootings around the country. They tried to get the school board to act, and they didn't. As a result, the students had no choice but to organize a peaceful protest. It should be noted that the students organized a protest off campus and during recess.
Counsel, wouldn't you say that the sheer number of students that showed up at this time is a substantial and material disruption of school?
Although there were many students present, still it was during a recess, which allows them to have that amount of students there.
Yeah, there are 500 of them. That, if I understand the statistics, that's a quarter of the school student population. They have 20 minutes of recess. This event lasted 17, which gives, if I understand the math right, a minute and a half on either side of this demonstration. You get them together, get them back to class. Why isn't that 500 students and try to do that in a minute and a half? Coming and going? How is that not disruptive?
Well, it was still during recess, so we cannot say that it did cause any with the educational activities, because we still have that 1 minute and a half that could be used to go dance.
There were students who were late back to class, weren't there?
Yes.
Do you agree that the late students is at least disruptive, if not substantially disruptive? It is a disruption, right, for students who are in class late?
Well, it depends. If the student comes in rushing and making a lot of noise, then yes. But we cannot say for sure that the students came in rushing and even making noise. The students could have easily.
Well, I'm just trying to get into what the Supreme Court's trying to tell us, right? We have to protect the First Amendment rights of students unless they're going to cause a substantial disruption, not just any disruption. So it is a little disruptive, right, for students to come into class late. Isn't the question whether that's a substantial disruption or just a kind of not very substantial disruption?
Well, although the students were late, we cannot say that it was substantial because we don't know how the students entered the classroom, and we cannot say whether they were 500 students late or there was 2 students late.
So who should have put on evidence about how the students were acting when they came in late to class?
You see the question?
Yeah. Should there have been some evidence put on in this case about what these students did when they came into class late? Whether they were being loud and boisterous and talking about the disruption, the demonstration, or whether they just came in quietly and sat in their seats?
Well, we cannot say for sure. Despite these very careful steps that were taken by the students, they were still suspended in a clear violation of their First Amendment rights. In this case, there is no interference with the school, since the protest was peaceful off campus and during recess. Also, in the Tinker decision, the court stated that in our system, undifferentiated fear or apprehension of disturbance is not enough to overcome the right of freedom of expression. In our case, what was the school district afraid of? What justification is
Well, that's the question, right? The question is whether the principal could predict there was going to be a disruption. It's not really, the question isn't really whether there was a disruption, it's whether the principal reasonably could predict the disruption. so didn't the principal know a lot of things that suggested to her that this was gonna be disruptive?
Yes, the principal actually did warn them, but a warning cannot overrule their First Amendment rights.
Sure. Did she violate their rights just by warning them?
No, but from the moment that it was warning, it was practically telling the students no, and the students were later on suspended, which was a First Amendment violation.
Well, the information she had beforehand is she's told 3 students can't do this, they're gonna do it anyway. And they've invited the press, and there's a lot of buzz around the school, and this is a somewhat controversial issue, as I understand it. The community's split 50-50 or thereabouts. Why isn't there a reasonable risk from the standpoint of the administrator, the principal? Why shouldn't she have a reasonable concern that this could all go crazy and we're not gonna allow it?
Well, this brings me to the Dodd case, which in the Dodd case, the court held that school officials do not possess absolute authority over their students, nor may they confine in them expression of those sentiments that are only officially approved. What better place than a school area for controversial issues? The facts that are closely parallel this holding, the students are engaging in a peaceful demonstration of a controversial issue. The Dodd case holds that prohibition of students' expression in school would be allowed if the school officials can demonstrate facts, which might reasonably lead school authorities to forecast substantial disturbance or material interference with school activities.
Why aren't the facts that I recited 2 minutes ago, why isn't that sufficient? Plus, that 500 students, a quarter of the entire school, gathering and then dispersing. Why isn't that a substantial risk of serious disruption to the educational process?
Because it was still during recess and we still had time to get to class, and although a couple students were late, we cannot say how many students were late. Given this case, the facts of this case were that there was no disruption to school, and I respectfully request that the district court decision be revised. I yield the remainder of my time to my colleagues.
Good evening, Your Honors, and may it please the court. My name is Solana Torres, and I will be representing the appellant on the issue of whether or not Principal Bitter's search of Appellant Rouser's backpack was justifiable or not. Because the search was unreasonable and Bitter lacked direct evidence to build suspicion against Rouser, this search was indeed unjustifiable. In TLO v. New Jersey, it is established that in a school search, a search is legal if the action is justifiable in its inception.
Also, isn't the definition of reasonableness something that the principal can exercise? Because you don't have to have a higher standard, right?
Yes, Your Honor. Well, reasonableness is it needs to be held by common sense. And under Ornelas v. the Supreme Court, we see that it is for reasonable suspicion, there needs to be common sense and other non-technical conceptions established for that to be so. But in this case, you can see that the principal did not have sufficient evidence prior to this to reasonably assume that they would be able to search the student's backpack.
Well, there were some facts that the principal knew about that before she made the decision to search the backpack, right?
Yes, Your Honor. So we can look at the facts. First, we see Bitter smelling a scent of smoke as the students left the office after speaking to her, and we see the students.
Do we know how long before the search that happened?
That happened, I believe it was a few days before, during the time of the protest, or prior to the protest, excuse me. And we also see during a news coverage, the principal saw Rouser holding a cylindrical object. Also, several months prior, Bitter had seen these same 3 students in the mall smoking a cigarette. However,
So aren't these causes for reasonable suspicion to cause the principal to look and search?
no, Your Honor, these are not. So let's look at each individual case. In the case of the cylindrical object on the television, this object was not, it was clearly stated in the fact pattern that the principal had no idea what this object was, and just assumed.
But there was more than that, right? When she met with Rouser, didn't she tell him that she saw him with some object, and didn't he lie to her and say, you know what she was talking about?
I believe that he did say that there was no object. However, this is still not grounds for the principal to search the backpack because this object.
There's this idea that if you lie, that suggests that you're aware of your own guilt, and that might raise an inference. If he's lying about that, then combined with all the other things that she knew about his smoking, why wasn't it reasonable for her to draw the inference that he might have a smoking paraphernalia?
Well, Your Honor, you have to look at the direct facts of the case. So, for example, this cylindrical object might well have been something completely legal. It could have been a pen, it could have been a lipstick, it could have been a gum package. There are a multitude of options that the principal could
But
have
he
assumed
didn't
were
say, when she asked him about it, he didn't say it was a pen
legal.
or whatever, some other innocuous thing.
Yeah,
He just denied having it, right?
Yes, although this is the case, looking at the other facts of the case, for example, seeing the students smoking in a mall. This is definitely something that might have contributed to the principal searching the bag. However, when you actually look at the situation, in the mall, these students were over the age of 18, so it was legal. They were in a space that was completely acceptable to smoke. They were not on school campus. So there's no reason for the principal to automatically assume, despite these other situations that.
Besides, if that was enough, the principal could probably search every kid at school, right?
Exactly.
Hang out at the mall, go search all the kids at school.
Yeah, because they were not on school premises at that time. It was completely legal, so she can't just assume that they would engage in illegal activity for that.
Is it actually legal to smoke at 18 in California?
Yeah,
It
well,
was 21.
well, in this
I
case.
mean, I know it's not material, never mind, I shouldn't.
Okay.
It's not material.
Yeah, well, in
Go
this
ahead,
case,
go ahead.
it would say that it was legal.
I'd like to, you focused on, she saw them smoking. Okay, we know they're smokers. There's no question about that. Legal or illegal, they're smokers. She knows she's dealing with 3 smokers. She thinks she smells some during one of the meetings. Then she sees something pass from Rouser's hands, cylindrical. Well, that's cylindrical, but so are a lot of vaping devices, like the Juul. And then, having those facts, he lies to her. Why doesn't that, putting all those facts together, why doesn't that lie trip the red light and give her good reason to look into his backpack?
Yes, well, because despite the fact that he may have denied having a cylindrical object, this doesn't give a justification. It might have been a hunch, but under Ornelas v. the Supreme Court, we see that a hunch is not grounds to allow this search.
Counsel, you're focusing on one fact in isolation. Don't you have to look at all of the things kind of building up to this climactic lie? And isn't that, and maybe this is a second question. You have to have more than a hunch. It has to be a reasonable suspicion, and common sense is involved. Can you tell us how we draw the line between what's a hunch and what's a reasonable suspicion? Particularly given these facts, why doesn't that cross over whatever the line is into reasonable suspicion?
Right, well, you need to observe the totality of the circumstances and look at it as a whole picture. So when we do that with this case, we see that Bitter claimed to have acted on these suspicions she witnessed from the students, including seeing them with a cylindrical object, smelling smoke, seeing them at the mall. But when you have a common sense analysis of this case, there could be just so many lawful options and lawful conclusions that Bitter could have drawn, not leading to this assumption that there was a illegal material in Rouser's backpack.
Are you arguing that would not be one of the many things you might infer from these facts? And if it is one that you couldn't reasonably infer, why isn't that enough?
Well, this is still not justifiable because this needs to be, the preceding events all have to add up in a way that would lead this to be the sole reason. And and this to be the main assumption that could be made, and it has to be completely justifiable and completely within reason that bidder would decide to search this backpack and exercise this search. So when we look at this case, we see that these events prior to the search did not give strong enough evidence to bring incrimination and reason to search the bag. So with this, I would like to pass the rest of my time to my counsel. Thank you.
Good evening, Your Honors, and may it please the court. My name is Mariana Netrath, and I'm representing the appellant in issue 3. I would like to get straight into the facts and look at the case, the seminal case Graham v. Connor of the Large v. Berkeley. In this case, it is stated that the police use of force, it is examined to see whether it does violate a student's or someone's Fourth Amendment rights based on whether it is objectively reasonable under the circumstances. First, when looking at the circumstances, this was no threatening situation for the officer to be in. Merely there were a few students standing on the side.
Counsel, wasn't the safety of the students a substantial reason for the officer to be involved and exercise the steps that he took?
The safety of students is an officer's priority. However, these students were standing on the sidewalk before the officer ever did get involved. It could be said that the only reason that this led to the point it did is because the officer came out in the first place. But we could also say that the officer inflicting pain on others, on this student, was not going to keep the student safe or out of pain.
Is one of the things we have to look at what kind of force was used, how we characterize it? I'm not sure the cases are very consistent about that. What level of force was used by this officer?
Well, actually, in the Graham test, it is stated that a baton jab and baton overhead strike, which is what the officer did use eventually, are considered immediate types of immediate force, which are.
And what was the government's justification for using immediate force in this case?
Your Honor, that's what I'm trying to figure out myself. I can't find a reason that the government would be interested, that there's any governmental interest in the first place, which is also under the Graham test.
Well, but, I mean, we can infer that the officer wanted to prevent Ben from getting hit by a car, right?
We can infer that this might be right. However, the student was in no danger of getting hit by a car. The student was on the sidewalk conducting a peaceful protest. That is until the officer came out to the sidewalk and started provoking the situation, which is what led.
If I'm right, my understanding of the facts is the officer didn't do anything but come out on the sidewalk. At that point, the student stepped out off the sidewalk. The officer told him to get back, tried to get him back. The student said, essentially, leave me alone, go about your own business. As the student is escalating. He's challenging the officer's authority. Why doesn't the officer finally have to get his attention?
Well, to go back.
Pay attention and go back.
To go back from where you started with the students walking into the sidewalk, we can look that they merely walked in, the bike lane. They walked into the bike lane and there was no immediate danger. In fact, a car was honking and it seemed like solidarity with the students at that point. And it wasn't that the students were in danger and that the car eventually swerved out of the way until the officer did reach and try to pull the beaten back onto the sidewalk. That's where the danger first came from, was when the officer tried to pull the students back onto the sidewalk.
You're saying after that, the student stepped out into the street to try to get away from the officer?
Yeah, that's when the student moved into the lane.
What do you think the officer should have done? The officer yelled at him, get back on the sidewalk or something, yelled at him, and the student didn't do anything. What should the officer have done?
The officer had other options. The officer could have used even more verbal warnings. We don't know what could have happened from that. The officer also had handcuffs on him that he could have used, but he should not have gone immediately to such an immediate force as an overhead strike of a baton, and also a baton jab. Furthermore, these baton jabs and baton overhead strike did leave Beaton with some injuries, which include bruising to both his chest and his arms. And we can also use that to say that there was an intrusion on his civil liberties under the Graham test.
Doesn't there have to be something more than minor injuries that do not require hospitalization or medical attention? Doesn't it have to reach that level before we are concerned about First Amendment rights?
Well, in this case, we're more concerned with Fourth Amendment rights, I suppose you could say. But, we're comparing the force used with the severity of the injuries. And in this case, he got very lucky that he only sustained that injury because officers in California are actually taught that batons are a deadly weapon and should only be used in response to a combative or aggressive act, which certainly was not Beaton's self-defensive swing at the officer with his sign.
I was just going to ask about that. Doesn't the officer have to, as the situation is escalating, now the student is trying to hit him with his sign. The officer needs to get his attention and get him to get back to safety, doesn't he? And protect himself.
While he might have thought that he needed to protect himself, certainly using a deadly weapon, as it is stated in the Young v. California case, was not the response to merely a swing of a sign, when he had other options such as handcuffs to use to try to get the student back to the sidewalk. He could have used more verbal warnings. He did not need to jump immediately to a baton jab or an overhead blow of the baton.
We're a court, we're not a police officer in a potentially emergency situation, trying to maintain order and protect this student's life. Yes, there are a number of things that the officer might have done, we don't know what the result would have been, but can we really fairly judge, sitting here on the bench, what was the reasonable thing for the officer to do in that situation? Don't we have to leave that to
Councilor,
him?
I see your time is up, so I'll let you answer this question.
Thank you.
Thank you. So yeah, we cannot assume, Your Honor, what the officer was thinking in the moment, whether the officer felt like he was in danger. But certainly if the officer was really trying to keep the student safe, he would not inflict such pain and intrusion on the student's Fourth Amendment rights, such as to hit him with a baton, which is a deadly weapon.